Okay, so it's about 15 of us. I know we are expecting a few more, so if a couple of people sort of jump in through my little introduction, then that'll be absolutely fine. So I wanted to firstly welcome everyone to the first WSP Solicitors webinar that we're running. It's called Safeguarding Your Future. My name's Silas. I'm the marketing manager here at WSP. I really wanted to sort of thank you all for your time. Thanks for coming along, and hopefully we can really give you something that's going to be of sort of real value that you can take away, and sort of really help. We are going to be taking questions throughout, so we've had a few that were submitted prior to the webinar starting, which I've got here. If anyone's got any questions throughout, if you can send them over to Janine, that would be fantastic, and then she can sort of pick which ones she can answer. We will be recording this as well, so I will make sure that a link to download the recording of this webinar goes out to all of you. And I am also going to put out a bit of a survey as well, just to get a bit of feedback. As this is our first one, it'll be really good to know what you liked, what you didn't like, if the time of day works, things like that, just so that we can continuously improve what we're doing. So WSP Solicitors, for those of you who don't know, we are based in Gloucestershire. We've been serving the community for about the last 250 years, which is really impressive. Offices in Stroud, Dursley and Gloucester, and we cover loads of aspects of personal law as well as business and commercial law too, and our sort of overriding mission is to just make life less complicated for all of our clients and partners. So that was sort of the introduction to everything. I think we've had a few more join us, which is great. So thanks anyone. If you've got sort of any questions throughout, do direct them to Janine. But yeah, I'll hand over to Janine now, who is a chartered legal executive within our wills, trusts and probate team here at WSP. Janine, over to you.
Thanks, Silas. Morning, everyone. Welcome to our very first webinar. We're discussing today safeguarding your future. What exactly does that mean? Well, safeguarding your future really means putting things into place so that you or your loved ones are looked after in your later years, effectively. It doesn't really just relate to later years, it could be at any age, but it's sensible to put things in place so that your future is safeguarded. So starting on with lasting powers of attorney, let's have a look at some of the common myths that surround lasting powers of attorney. So I'm okay at the moment. I don't need to do that just yet. It's just for old people. This is a very common one that we see a lot. You know, being okay is the perfect time to make lasting powers of attorney. It's when you are okay is when you should be making them. You should be putting those provisions in place to safeguard your future. You have to be over 18 and you have to have mental capacity to understand what you're doing, and there's no specific age. I've done lasting powers of attorney for 18-year-olds who are going off to college, or more specifically, not this current time, but going off travelling, and they put lasting powers of attorney in place should that be necessary. It means mum and dad can manage their funds back at home. They can step in if they need to, but it just gives that added reassurance. So there is no specific age at which you should suddenly make a power of attorney. To do so at any point as long as you're over 18. It doesn't just relate also to property and finances. You should also consider health and welfare, even if you're young. You never know. It's very sensible to put those in place at any age, provided you're over 18. My family will look after me and whoever is my next of kin. Just a second, I think I've got, sorry. Sorry, I thought I had people to let in. Apologies. Going back. My family will look after me and whomever is my next of kin. So if you're over 18, unless there is legal documentation in place, then the family won't have legal authority to make decisions about your property and financial matters and your health and welfare. Next of kin is another very common one. I think commonly because it's asked mostly at hospitals, who's your next of kin? So people assume that they have legal authority to make decisions. I quite often get told that when Uncle Albert was in hospital, the family were asked what their wishes were and the hospital abided by them. Well, yeah, they probably would have done, but if the hospital considered that the family's wishes were against what was best for Uncle Albert, they wouldn't have abided by them. It's simply the hospital being nice and just a mechanism just to see what the family's wishes are. I mean, with any mental capacity, you should always involve the family anyway, but the legal decisions are always made by those who have the power to do so. I don't need one. My money's in joint accounts. Well, even if this is the case, the joint account holder won't automatically have the right to take control of your affairs if you lose mental capacity. It's mainly there so that that protects anyone who is vulnerable against financial abuse and against fraud. I've already made a will. My executors will sort things out for me. People often get confused between a will and a lasting power of attorney and when they come into effect. So a will, as you will know, comes into effect when someone dies. A lasting power of attorney comes into effect when someone needs assistance or loses mental capacity. Lasting powers of attorney end at the point someone dies. I've already been diagnosed with dementia, so I can't make one. Not strictly true. It depends on a lot of factors. It depends on, you know, how far down the process they are. It depends on, you know, many factors really. Often when people have just had a diagnosis, that's the time then they really start to think about what they need to do for the future. They want to safeguard their future. They want to make sure that everything is in place. They want to make sure their wills are updated, and they want to make sure that powers of attorney are in place so that their loved ones can make the decisions necessary at the time. So as long as they've got the requisite criteria to make lasting powers of attorney, i.e. over 18 and with mental capacity to understand, then they can make lasting powers of attorney. Now, again, I've often seen clients who are attorneys, usually under either an old style enduring power of attorney or a property and financial affairs lasting power of attorney. And they come in because mum or dad's in hospital, they've lost mental capacity, and the hospital isn't telling them fully what's going on. They come in because they want to know what they can do. Sadly, not very much. So unless there is a health and welfare power of attorney in place, then it's unlikely that the family will be able to make those legal decisions. The only other option available to them would be applied to the Court of Protection, which I'll cover later. But again, a health and welfare deputyship is incredibly difficult to get. So it's incredibly important, and I argue even more important, to put the health and welfare power of attorney in place, as well as the property and financial affairs power of attorney, because it works to me like an insurance policy. So we've just talked about the myths. So what exactly are lasting powers of attorney? Commonly referred to as LPAs. It's a document by which you give someone or more than one person that you trust the legal authority to make decisions on your behalf when you lack mental capacity at some point in the future. It can also be used for the property and financial affairs power of attorney. It can be used when you have mental capacity but you want your attorneys to act for you. But I'll cover that in more detail later. So the person who is wanting to make the power of attorney is called the donor, and the people who are acting are the attorneys. So, and as I said previously, there are two types. One deals with property and financial affairs, and one deals with health and welfare, not health and beauty as I was asked for once. Can I please make one of those health and beauty powers of attorney? That would be nice. Okay. So what do you need to consider? So when you are making your lasting power of attorney, you need to consider, who do you want to appoint? You need to consider how many attorneys you want. You need to consider also how you want them to act. Do you want them to act together, or do you want them to act separately and together? So joint and several. Do you want to appoint anyone to replace them should they not be able to act? Do you want to notify anyone that the documents are being made? Do you want to include any preferences, which is the old style guidance and instructions? And do you want to include any information in relation to your health conditions? You should also consider the family history. So are there any religious and spiritual considerations that need to be taken into account? Is there anyone specific that the attorneys should consult with? So should they consult with a specific IFA? Should they consult with a specific medical practitioner? All of these things need to be considered in great detail when you are considering making a power of attorney. So when can the power of attorney be used? So they differ a little. So the property and financial affairs power of attorney gives you two options as a donor. You can decide when your attorneys act. They can decide to appoint their attorneys to act either as soon as it's registered, or secondly, when the donor has lost mental capacity. Now, when I go through those two options with clients, quite often they go for the second option. But again, careful consideration needs to be given to this, because if you go for the second option, if your body is weak but your mind is willing, and you are struggling to get about and deal with matters, then the second option doesn't really work for you. If you go for the first option, even though they can use it as soon as it's registered, it doesn't mean that they will. It's still within the donor's control. The donor still will give permission for the attorneys to act should they wish to. And any decision that any attorney makes has to be with consultation with the donor. They have to discuss everything with them. They can't assume, if they make a silly or a foolish decision, that they are unable to make any further decisions. We all make them. We all make silly decisions. We're human. So really careful consideration needs to be given when making any decision. If the donor doesn't really understand, then the attorneys must find a way of making them understand. They must find a way of trying to get them to understand in a way that is relevant to them, if that makes sense. So it may be, for example, I always remember being told this example when somebody was trying to assess capacity for a will. So the assessor was asking, so you've got an estate of, let's just say, 500,000. How much do you want to go to Uncle Tim? And he just couldn't understand. He couldn't get to grips with what each bit meant. So from a money point of view, he couldn't differentiate. His mind wouldn't work that way. So what the assessor did was he got a box of Quality Street that had a whole load of other chocolates in there. So big bars of chocolates and all sorts of different chocolates, and he tipped them all out on the table. And he said, so this is your estate. All of these chocolates are your estate. You've got big bars of dairy milk, you've got strawberry creams, you've got Twix bars, you've got mini Mars bars. So he said, okay, so this is all of your estate. How much of that estate do you want to give to Uncle Tim? So he gave him a couple of strawberry creams. So, okay, so Aunt Matilda, how much do you want her to get? So she got a family-sized bar of dairy milk. And so it went on. His understanding was, he could understand it from that point of view, but when it was actually figures, he couldn't quite understand it. But he knew by using the chocolate scenario that that represented how much was in his estate, and he could understand it that way. So, who can act as an attorney? Well, anyone who's over 18 and who has mental capacity to act. I mean, realistically, you would always appoint someone who fully you trust and that you know will carry out your wishes and act in your best interests. What types of decisions can an attorney make? So it really depends whether there are any restrictions that you yourself have put into the lasting power of attorney, but basically for a property and financial affairs lasting power of attorney, an attorney can make decisions such as buying and selling property, setting up bank accounts, closing bank accounts, claiming benefits, dealing with tax affairs, dealing with mortgage payments, maintenance, etc. They can even make gifts, but these are obviously limited. So, for example, they can make customary gifts, such as gifts for birthdays. So if you were giving £50 per grandchildren every birthday, that's fine. However, if the attorney suddenly hikes it up to £500 a go, then there's a bit of an issue there. Any gift has to have a history and a proven history as to what that gift has been, and then it will pass. Anything outside the realms of that has to be agreed by the Court of Protection. So also any decisions such as paying for private care, any carers coming in, paying for any equipment that the donor might need for their care, all of those decisions an attorney can make. For the health and welfare, they can make decisions such as where you live, what you eat, who you see, what you wear, what treatments you have, whether they can make decisions about your dental treatment, about your eye treatment, anything at all to do with your day-to-day life. If you think of your daily life and what you do in it without even thinking, someone else can make that decision for you. There is a separate section, as I like to think of it, within the health and welfare power of attorney that deals with life-sustaining treatment decisions. In this one, you can decide whether or not the attorney can make these types of decisions for you, again, when you've lost mental capacity. So these would be decisions such as, receiving care for cancer treatment if it's life-sustaining, antibiotics, artificial nutrition and hydration, anything that prolongs your life and you can't make the decision yourself, someone else can make for you. So who decides if you don't have mental capacity, and what is it? So when you're making a lasting power of attorney, typically if you come to see us, we would assess you and make sure that you fully understand what you're doing. If we have any doubts, then obviously we would seek medical opinion, but we normally have a good idea as to whether somebody understands what a lasting power of attorney is and what powers they are given to the attorneys. At the point when your attorneys start to act and they act fully, then it's usually a medical professional. So it will either be a GP or it will be somebody like a mental capacity nurse, even a social worker. They can make assessments as to your mental capacity. And mental capacity is really very new. The Act itself only came in 2007. So in terms of law, it's like the baby of them all. It's only been going for about 13 years. It's constantly changing. Capacity is, I always say, a very grey area, because you can gain capacity and you can lose capacity. Just because you've lost it one day doesn't mean that you don't have it another day. You could be having a bad day. There are various things that affect capacity, such as UTIs. Any sort of water infection will affect your capacity. I've seen clients who've had UTIs and they're a completely different person once the infection has cleared up. People have capacity sometimes in the morning, and then in the afternoon it starts to waver. I always remember going to, when my sister got married, we had to go and do something every weekend. It was turning into one of those. And this particular weekend we were going to get our nails tried out and done, as you do. And the lady that was doing my nails was totally lovely, but she did have some mental health issues. And I'd previously gone to her in the morning, she'd been absolutely fine. In the afternoon, she wasn't so good. And she literally, because she couldn't cope, her mental capacity would be in a form of sort of falling asleep, and she would just sort of lose all control of her faculties in a way. And she literally, I was just remember just sat there with my hand, having my nails painted, except it wasn't my nails that were being painted, it were my fingers. And so but if you saw her in the morning, for example, no issue at all. So capacity has to be decided on it being a fact-based and decision-based basis. So it depends what the decision is. And for example, again, you can have capacity to make one type of decision, but not capacity to make another type of decision. So you could not understand what your financial information is, but you could understand what your health and welfare details are. You could understand about treatment, you could understand what that means, but you might not understand what the cost of it was, for example. So what about enduring powers of attorney? What if you have one, and is it still valid? Well, the short answer is yes, they are still valid, provided that they have been validly executed prior to the Mental Capacity Act coming in. So as long as they were properly executed by the donor and the attorneys before the 1st of October 2007, then they are still in place and still valid. However, there are a lot of EPAs that were made that had restrictions put in them, and the restrictions typically would be ones such as the power of attorney can't be used until it's registered. Now, the difference between an EPA and an LPA is that an EPA can be used without any restrictions, without being registered. This is partly why it was changed in 2007, because they were very easy to make and very open to abuse. So that's why lasting powers of attorney were brought in, and then the Mental Capacity Act brought in the health and welfare side, and it just made things a little more safe for the donor. So provided that your EPA is validly executed, you can still use it. The difference here is that whereas with the lasting power of attorney, the donor can register it, with an EPA, the attorney is the one who registers it. The donor doesn't have the option. And the attorney has the job of deciding when that person loses capacity. So effectively, the attorney has to register the EPA at the point they believe that the donor is losing or has lost mental capacity. They are under a duty at that point to register it. So if you do have an old style EPA, or you know somebody that does, please do get it checked. It may still meet your needs, but it may be sensible to look at making a new style lasting powers of attorney, because they can be used once registered. So it does mean that it makes life easier for the donor and for the attorneys. And it's just sensible really to review these things. The other slight issue, I would say, with EPAs is that because they don't have to be registered with the court to be used, the banks sometimes don't understand that. In their heads, a lasting power of attorney is registered and it can't be used until it's registered, whereas an EPA can without a restriction. So when somebody sends in an EPA to a bank, they quite often get a lot of difficulty with the bank because they reject it saying it has to be registered, which of course it doesn't. That's not necessarily a reason to change, but it's just a factor to bear in mind that there are some issues with the old style EPAs, and sometimes it is sensible to upgrade, I guess, your upgrade to a lasting power of attorney. So can you revoke a lasting or enduring power of attorney? Short answer, yes, you can. If you find that your lasting or enduring power of attorney no longer meets your needs, it could be that your attorneys themselves have lost mental capacity, or that simply things have changed, particularly younger people where they've made a power of attorney and they've grown up and got married. Sensible then for the power of attorney to be revoked and new powers of attorney made. So that's done by a deed of revocation sent to the attorneys, and if it's registered, sent to the Office of the Public Guardian as well. So what if you have a business? Is that covered under a lasting power of attorney? Well, you can have a separate lasting power of attorney for your business. So you have a personal lasting power of attorney. Would you want the attorneys under your personal lasting power of attorney dealing with your business? To have a business power of attorney, you should choose attorneys who understand the business and are able to run it for you. You need to look at things such as the Articles of Association, you need to look at shareholders agreements, you need to look also at any partnership agreements. You need to see whether the lasting power of attorney being made is likely to have any conflict with those documents. You need to appoint someone that understands the business, and this is sometimes where some people do have some difficulty. So if you've got a business that has 3 partners and you are looking to appoint one of the partners as your attorney, there could potentially be some conflict with the attorneys because what may work for, let's just say that I'm appointing John to act in my best interests under the business that we run with somebody else. So John goes into the meeting, I've lost mental capacity. He goes into the meeting, the proposal is made, it works for him, but it wouldn't work for me. So he's then in a very difficult position. Does he then agree to do what's best for him, or does he do what's best for me, putting himself at a disadvantage? So careful thought again needs to be given in relation to who you appoint under a business LPA, but it is very sensible to also make a business power of attorney. So what will happen if you don't have a lasting power of attorney in place and then you lose mental capacity? So in this scenario, obviously your loved ones won't be able to make the big decisions for you. They won't be able to manage your financial matters, and they won't be able to make decisions in relation to your healthcare. The only options available would be to go to the Court of Protection and apply for a deputyship order. This is an order which will be authorised by the court to appoint somebody to manage either or both of property and finances and health and welfare. So what is a deputy? So a deputy is someone who is appointed by the Court of Protection who will make decisions on behalf of the incapacitated person who the court refer to as P, or patient. It can be, as I've said, for the property and financial affairs, or it can be for health and welfare. Everything always has to be made, any decision made has to be always in the best interests of P. So what can a deputy do? So a deputy can carry out similar tasks to an attorney, However, the deputy can only act within the terms of the order. So if, when applying for a deputyship, the property is not likely to be sold, then if at a later date the property is needed to be sold, then another application will have to be made back to the court to get permission to sell. The court order is very specific in what a deputy can and cannot do. Again, can make customary gifts such as weddings, Christmas, birthdays, as before. But again, anything beyond that has to be authorised by the Court of Protection. So will the court grant an application for a deputy to be appointed? For property and financial affairs, pretty much yes, they will, provided that there are assets to manage. If a person only has benefits and nothing else, no property, then there's absolutely no point applying to the court for an order, because it's just income coming in. So the court in that instance, it would be a waste of money, and what the court would suggest that is an appointee is appointed by where you apply to the DWP to become the appointee to manage the incapacitated person's benefits. If there are assets to be managed, so if there is a property and there is money, then an application would usually be successful, provided nobody objects to it. And what will normally happen is that the court will grant the order. They will have somebody, a court visitor, come out and meet with the new deputy. They will supervise them, make sure they're doing everything correctly. They will also ensure that a report is submitted every year detailing what's been spent, what decisions have been made, who has been asked to provide information and assistance, and provided that the figures match, the court won't have an issue with it. Obviously, if there's been money spent that shouldn't have been spent, then the court may well have an issue with it. But provided that everything has been done in the incapacitated person's best interests, and it can be shown that that's the case, then the report will just go through. Sometimes there's a slight discrepancy of a few pounds, and the court will just require an explanation as to why that is. But normally, unless there is a huge discrepancy, the court will usually just accept it. Health and welfare, very different. Health and welfare orders are extremely rare. So for a health and welfare order, you have to have exceptional circumstances. The court will want to know why they need to be involved. They will want to know why you need to be involved, and they want to know why a one-off order of the court couldn't just be made. So, for example, if you have an elderly relative, and this is normally pretty much the scenario that always happens. So if you have an elderly relative who has gone into hospital, capacity is not there, and they're put into a sort of respite before they go into a care home, usually at that point, children, family come and see us and they want to make a health and welfare LPA for their relative, which of course they can't do. Now, the court won't grant the health and welfare deputyship for an older person. They are extremely rare, and they will only do so if there are good reasons. So if your relative suffers from Alzheimer's or dementia and is already receiving a form of care, it doesn't matter whether you don't like that care, they are still receiving care, and the court will not interfere. Which is again my argument for why a health and welfare LPA is so important. However, if you're younger and you have a learning difficulty that is severe, that means that you don't have mental capacity, as soon as you turn 16, your parents can apply for a health and welfare deputyship, and provided that we can show to the court that there is an ongoing need for care to be provided, and the care needs as such, that a one-off order of the court wouldn't work. So where someone has very complex health needs and there is a need for constant sort of assessments and decisions to be made about that person's medical treatment, then it's more likely that the court will order health and welfare orders to be made for that person. And I have got quite a few through on that basis. But for elder people, rare as anything. So again, that's why it's so important to get these in place when you can and when you're able to, when you're okay. So who can be a deputy? And again, similar to lasting powers of attorney, anyone over 18 and who has mental capacity. It's usually a family member. It could be the local authority if there is nobody. It could also be a firm of solicitors. And the court, if there's absolutely nobody, the court will appoint a panel deputy, which is usually a solicitor, and it will be somebody that is within their panel of people they can choose to give work to. So what will the court consider? So they will consider the connection. So what is the connection to the incapacitated person and the person making the application? They will consider what the reasons are, what the benefit is to the incapacitated person, and whether that benefit can be achieved in a different way that doesn't require the court order. Okay, so the one thing that always worries people, what if something goes wrong? So if something goes wrong, then with a power of attorney, the Office of the Public Guardian is there to investigate should there be any issue with any attorney. However, you choose attorneys that you trust. So you trust your attorneys to always act in your best interests and to do what is right for you and to manage your funds and look after you and make your health decisions in the best way possible. However, the Office of the Public Guardian is there to deal with any problems that do come up. This can result in them going to court. It can result in them being stripped of their appointments as attorneys and a deputy appointed. It can result in investigations by the local authority. It can result in the police being called. So there are quite strict powers in place for the Office of the Public Guardian, and I've been on the other side of the OPG when they have been up against somebody who made a mistake and gave funds out of the incapacitated person's funds, believing that's what they would want, and they were like a dog with a bone. They would not let go. They wouldn't agree to any half measures, or the local authority had already investigated and found no wrongdoing, but they ordered and got the court to order that the local authority investigate again. So they have got some very strong powers. Having said that, apart from choosing the right attorneys, what can you put in place should something go wrong? Well, you can include a supervision clause in your power of attorney. That would be usually in the preferences section, and it would include the duty to consult with a third party. So it could be a firm of accountants, it could be a firm of solicitors, financial advisors, depending on what was needed. Always sensible to take legal advice on this to make sure that your attorneys, when the attorneys come to act, sensible for them to come to us to make sure that they understand what they need to do. Because sometimes things are included in lasting powers of attorney that are not necessarily ones that we have drafted, that don't always work in law. So the LPA or that part of it may be invalid. Sometimes also one of the common ones I've seen is where people have said that they want their attorneys to act jointly and severally, together and independently, and yet under instructions they say that they want the attorneys to decide together jointly on any sale of the property. Now, if any of those attorneys can't act, it's not a joint decision. So therefore that decision will have to go to court and be decided on by the Court of Protection. So the other thing you can put in place, which is relatively new and I think is great and about time, is you can put a bond in place. This is similar to what you would do for a deputyship. So with a deputyship, the court decides on a bond based on the value of your assets. And obviously, if your deputy then goes off and has fun on your money, then the bond could be called in and you're put back in the position you were before they spent all your money. The LPA bond obviously works in the same way. So that will cover misappropriation of funds, an honest mistake, and substitute attorneys. So it will cover those following replacements. They've also, the OPG, just introduced a new system as well, where you can view your powers of attorney online, so you always know what's going on with them. And it's got a summary on there. You can check to see whether it's valid. And it's just you and your attorneys that would have access to that, so that you could always see what's going on with that document to make sure that everything is still valid. So timescales. So lasting powers of attorney, once we've seen the clients and the documents have been signed by all of the attorneys and the donor, we will often act as certificate provider, certifying that they know what they're doing, that they have the requisite mental capacity to make the powers of attorney. The documents then are sent to the court for registration. This can take approximately 3 months to register. Depends on timescales, obviously, with the situation at the moment. I think it's slightly getting better at the moment, but it has been a bit delayed, obviously, because of the current situation, with the fact that we're working from home and, you know, the system isn't the same at the moment, and we do have to make some allowances for that. For deputyships, it's a little longer. So from the point that the application goes to court, and the application is more complex than for powers of attorney, we need to get a form of assessment done, which has to be on a prescribed court form. We have to get all the financial information, or we have to get all the medical information there. So the court has to look at that, and it's got the whole picture all in one go. So from the point it goes to court, it takes approximately 5 to 6 months to come back. That is without anyone objecting to it. So a usual one where someone might object would be a health and welfare power of attorney, particularly the local authority might object. That does happen. And in that case, it sometimes goes on to be in a full hearing, but that's happened probably about 3 or 4 times in my dealing with these matters. On the whole, they tend to go through, but the property and financial affairs ones don't tend to get challenged too often, unless there is a family member who feels they've been excluded, and then potentially there may be a challenge there. But without a challenge, it's usually 5 to 6 months from the point that it comes back, goes to the court. Sorry, not comes back, goes to the court. And then what happens is, after all the documents are served, the court will issue a bond that has to be paid. That's the surety bond. And once that's paid, they release the order. So costs. So our costs for powers of attorney are, for one person, if they were doing just one power of attorney, 500 plus VAT. If they were doing both, it would be 750 plus VAT. If you had a couple doing one, 850 plus VAT. And then if a couple did both, it would be 1250 plus VAT. The court also charges £82 per document registered. For deputyships, our costs are anything between 1,500 to 2,000 plus VAT. There's also the cost of the court fee, which is £365. There's also the cost of the capacity assessment, which is down to whoever is assessing. That can be from £50 up to about 600. It really depends where you are having to get the assessment from, because some GP surgeries refuse to do them. So some people are left with the only option is to get an independent person in, and that's when they start to get expensive. there is also an assessment fee to be paid, a supervision fee to be paid, and the bond to be paid. All of that is obviously paid out of the incapacitated person's funds once the order is through. So how can we help? Well, as a department, we've got a vast experience in dealing with powers of attorney, dealing with deputyships, and everything else, wills, probate, etc. So we can advise you on drafting powers of attorney. We can help you when things go wrong with them. We also act as attorneys ourselves. We act as deputies ourselves, and we can advise again lay attorneys and lay deputies on their ongoing journeys. So any questions? See, I've got a couple in here.
Thanks a lot, Janine. So I've taken down a few of the questions that some of the attendees have put forward, and like I said, we did have a few submitted beforehand as well, which is really good. But I'll start with the guys who are definitely here. So firstly, whilst you were talking about enduring powers of attorney, Michael Anthony put in a question, which was, once registered for finance, in brackets, and the donor's hospitalised, can I just start writing cheques, or do I have to go and register with the bank?
You would have to register it with the bank, because the bank needs to know that that authority is coming from you. What they will tend to do is you take the power of attorney into the bank with your ID. They will then register register the EPA onto the system. And then usually the account name will change to be in the attorney for, and at that point you can start to write cheques. But the bank needs to be informed.
Brilliant. Kay Willis has asked if we're going to be doing any other sessions on things like putting property into trusts, inheritance tax, things like that. I know from my point of view, the plan is to sort of really continue these sessions and cover a really wide range of topics.
Yeah, absolutely. Yeah, we are intending to. Any suggestions are always gratefully received as to what you want to hear about. We are definitely looking at doing that. We are looking at also doing talks on when your loved ones are going into care, what you need to consider, what you need to think about, what you should be looking at with the care contract, what assessments should be done, that type of thing. We're looking at doing one of those. So if there are any other talks that you would like us to do, then definitely please let us know.
I think I did say at the beginning, in case anyone missed it, that I am going to send out a survey as well with the recording of this webinar, just so that we can get a bit of a view on content and the sort of things you might like to see, and if the timing and the day worked out for people and things, just so we can sort of really optimize what we're putting out. So Janine, some of the questions that we did have submitted beforehand as well. One was, can I change who my attorney is later on if my circumstances change? Yes,
yes, you can. You can, so for example, if you have an attorney that you don't like, suddenly for some reason you don't want them to act for you anymore, you can do what's called a partial revocation. So that's a partial deed of revocation. If you though want to put somebody else in their place, you can't do that. You can't add to the document, but you can remove. So in that case, if you wanted to add somebody in, you would need to make a new document. So revoke the whole of the original document and then make a fresh one. But you can remove one person.
And the last one, unless anyone's got any more, I have seen a few things pop in the Q&A box. Can I object to someone setting up a lasting power of attorney for a loved one if I don't want them to set it up?
Yes, you can. You can. What will normally happen is you should receive notice. Not always, but you should receive notice to say that the powers of attorney are being made. You do have a right to object to that if you believe there are good reasons why that person shouldn't be appointed as an attorney. There is a system in place that allows for you to object.
Brilliant, thank you. We have had quite a few questions come in now, which is great.
I've seen one. Can I just pick one up, actually?
Go for it. Yeah, please do.
Helen says, can an attorney change a donor's will? No. Short answer is no. What you can do is, so you can't change the will, but what you could do is, if you believe that there is a necessary reason for doing so, you can apply for a statutory will, which is through the Court of Protection again. And again, the court will look at, it will look at previous wills, it will look at the incapacitated person's past wishes and thoughts, their history, and the court will then decide on what the will should be. But an attorney cannot change a will, but an attorney can apply to the court for a statutory will, if that's appropriate.
Thank you. Are there any more that you can see that you'd like to pick out? I know there's been a couple.
Yeah. Does an EPA cover welfare? No, it doesn't. So an EPA, Silas, you said, oh God, in a minute. Does an EPA cover welfare? No, it doesn't. EPA is only financial. EPAs came in before the Mental Capacity Act. Anything after the Mental Capacity Act covers welfare. Anything before it, no. There is the Mental Health Act, which is slightly different, but it doesn't, no, it doesn't cover it at all. And then says Silas, you said EPA, I was meaning LPA. Same answer, Michael. Same answer. Still need to register it with the bank. Is the LPA in place until a revocation is complete? Yes. Yeah. You can serve the revocation on the bank. At that point, they will stop taking notice, and you can send it into the to the OPG. But often, whilst you've already served notice of the deed, and you know, strictly speaking, that should be the end of it, until the Office of the Public Guardian registers it. It tends to be a bit of a grey area, to be honest, and it should be revoked straight away, but often it isn't until the OPG deals with it.
Brilliant. Thank you, Janine. So if there aren't any more questions, like I said, I will be sending out a link to download the full recording of this. So I'll send that to anyone who couldn't make it here on the day with a survey. And if you do have any questions that sort of just crop up, feel free to respond to my email, and we can get those answered for you. There will be more of these, so please do keep an eye out. And yeah, thank you all very much for your time. Thank you for attending. And yeah, we hope to see you soon.
Thank you. And yes, and again, any suggestions, we're always very welcome to hear them.
Thanks a lot, guys.
Thank you. Thanks. Bye-bye.